Well, good evening, everyone, and welcome back to AJ102, Introduction to Law Enforcement and Criminal Justice Online. Tonight's lecture is going to be on Chapter 8, which is titled Policing Within the Law. Now, quickly, just as a reminder, don't forget to look at the key terms. Especially in this chapter, there are quite a few key terms that are at the beginning of the chapter, and then also take the time to look at some of the discussion questions at the end of the chapter. I think that those will greatly assist you in doing your weekly quizzes and your chapter exams. So we have a lot of information to cover this evening, so I'm going to go ahead and jump right into Chapter 8, and I will skip past the learning objectives because we already know the routine. You have probably already read those, but as a reminder, make sure that you go through them as well. Now, decency, security, and liberty alike demand that governmental officials shall be subjected to the same rules of conduct that are commands to the citizen. In a government of laws, existence of the government will be imperiled if it fails to observe the law scrupulously. Our government is the potent, the omnipresent teacher. For good or ill, it teaches the whole people by its example. Crime is contagious. If the government becomes the lawbreaker, it breeds contempt for the law. It invites every man to become a law unto himself. It invites anarchy. To declare that in the administration of the criminal law, the end justifies the means, to declare that the government may commit crimes in order to secure the conviction of a private criminal would bring terrible retribution. Against this pernicious doctrine, this court should resolutely set its face. Now, this synopsis was delivered by Supreme Court Justice Louis Brandeis in Olmstead versus United States. Now, this was a court case from back in 1928, and says in effect that government agents, including police officers, are subject to certain restrictions in enforcing the laws, and those entrusted with that responsibility of protecting life and property must understand the principles of federal and state constitutions and the duties that flow from their application, as well as many laws and statutes that have been enacted. In short, police officers must know the law without the benefit of having to have gone to law school. Any violations of the law can result in evidence being disallowed under what we know as the exclusionary rule. Wow, so that's a good way to kind of get this chapter going when we're talking about policing in the law. And again, this chapter has a lot of information, so I'm going to hit the high points, and I hope you take the time to fill in some of the other information. And I have a couple of things in the introduction that we don't have time to watch, but I've put the link in here to a really interesting video on reading your mind. And so if you want, take the time to watch the video and ask yourself the question when you're done: how does this video and the contents therein apply to the Fourth Amendment? And can you see any type of law enforcement use? And when you're done with that, take another couple of minutes and read this article called A Search Warrant for Your Brain. In coming decades, it may be possible to use brain images as legal evidence. Super exciting stuff, guys and gals. So make sure you read it. And if you want to comment on it on the general discussion boards, you can, or send me an email or whatever. But it is really interesting information. So, although our Constitution guarantees to all persons equal protection of the law, police officers can and do exercise discretion in how they apply the law. And they select options on what actions to take under certain circumstances. And it can be something on a large scale when we're talking about discretion, and it can certainly be something on a smaller scale. And if you look at what discretion is, it's defined as the power or right to decide or to act according to one's own judgments. And elements of the criminal justice system, such as law enforcement officers, prosecuting attorneys, judges, correctional officers, probation officers, are faced with discretionary decision making throughout the entire criminal justice process. And that's really pretty big. So a kind of a fun example of discretion would be, let's just say that you are all patrol officers. That's pretty awesome. And you're working in your city and a car goes zipping by super fast, so they're speeding like crazy, and you get behind them and you turn on your lights and you execute this awesome traffic stop and everything goes great, and you walk up to the car and they roll down the window and it's your mom. Are you going to write your mom a ticket? Or are you going to let her go? I mean, I'm just going to let that kind of sink in. Now, that's a fun discretionary thing. And some of you might say, heck yes, I'm going to write mom a ticket because of she made me eat my peas when I grew up or was growing up or whatever. Or some of you are going to say, heck no, because my mom will slap the you-know-what out of me. So, I mean, it can kind of go either way, but this is discretion. And it's huge when it comes to law enforcement. And it's specifically huge when it comes to a lot of things that are taking place around the United States right now as it relates to use of force. And even one of the Chief Justices kind of chimed in here, where Chief Justice Warren Burger once said, the officer working the beat makes more decisions and exercises broader discretion affecting the daily lives of people every day and to a greater degree than a judge will do in a week. That's pretty impressive right there. And that shows you the level of even how a Supreme Court justice would view discretion in law enforcement. Now, as we kind of touched on just a little bit, officers need to know their own state's laws and precedent cases, as well as those emanating from the Supreme Court, because these are those big precedent cases that I was kind of talking about in a couple chapters ago. And any violations of law can and will result in, for the most part, evidence being disallowed under this thing they call the exclusionary rule. And that's the Weeks versus United States case. I would suggest that you might look at that. Now, no liability is attached to that unless evidence indicates that the officer was guilty of some type of willful or malicious wrong, but nevertheless, you can still have your case kind of messed up because you didn't take the time to properly obtain evidence in whatever or however you were investigating the case that we're talking about. Now, one of the myths that is out there is that police always have discretion in determining whether to issue a citation or arrest someone. Well, for the most part, that's true, but there are some things out there and some times when the police don't have discretion in the matter they are enforcing. An example could be an incident involving a court order issued by a judge or a magistrate. That order is in violation, or if that order is in violation and it states that the officer shall arrest, then the officer is obligated to enforce that particular order. So there's a couple of instances that I can think of where you would have to do that, but otherwise we do have in law enforcement quite a broad range of discretion. Now, some interesting research by the three authors that are up there on the screen now. So it's Stoshine, Alpert, and Dunham, and this was done back in 2008, examined informal working rules that govern police behavior and affect their discretionary decision making as it relates to when to stop and who to stop and who to arrest. And you might think it's kind of funny, but let's take a quick look at it and see how it kind of plays into the conversation. Well, the first thing that they found was the importance of time and place and appearance. And that one was identified because officers look for things that don't fit. So those are one thing. So I mean, so if you were watching somebody that's looking into a jewelry store and they're standing out in front of the store and they have it's 105 degrees outside like it is right now, and they've got a long jacket on and a knit cap on their head and big bulges, in their pockets, it doesn't mean that they're a criminal, but would that seem out of place? The time of evening, like in an industrial zone, and it's 2 o'clock in the morning and all of the businesses are closed, but yet somebody is walking around one of the buildings. So the importance of time, place, and even appearance might have an impact on the officer's discretionary decision making. And then the other one that they found was do unto others, kind of being fair. And they found that officers would not take action if they engaged in the same behavior themselves, for example, not wearing a seatbelt. So that's another issue that would kind of come up that might affect their discretionary decision making. And then threshold, which means stopping only individuals who exceed a particular limit. An example for speeding. So they might be working traffic in an area and they're not going to stop somebody that's going 5 miles an hour over the speed. They might set a threshold in their mind of it's going to be like 10 or 15, and then I'll go ahead and make the stop. And then the last one would be what they call POP, or pissing off the police. And this is where the suspect's demeanor actually influences the officer's response to citizens. And leniency might be afforded to persons who treat the officers with respect, whereas the heavy hand of the law is extended to the persons who are disrespectful or ill-mannered or rude. So kind of an interesting 4 items that they came up with. So I mean, and think about the last one for a minute. No matter how professional you can be, if you make a stop on someone and right when you walk up to the window and they start with the MF and this and that and blah, 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 do you think that you're more likely or less likely to issue a traffic ticket? I'm just asking. And you can answer that yourself. But these are things that this research kind of brought out. Now, in situations where officers use discretion, their professional judgment to choose from alternative courses of action, again, there is no liability unless evidence indicates that the officer was guilty of a willful or malicious wrong. However, when there is no discretion, when officers are faced with a fixed certain policy, there would be no immunity. Now, although officers have broad discretion, they are guided by several constitutional amendments, and we're going to talk about some of that in a minute, and the holdings of the Supreme Court related to those amendments. And they also found that using professional judgment was one of those things that officers need to do. So again, this research kind of showed some working rules that govern police behavior, if you will. So when we talk about some of those amendments that I just mentioned a minute ago, some that that law enforcement needs to abide by, the holdings listed in some of these, let's look at the Fourth Amendment. So the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued but upon probable cause supported by oath or affirmation, meaning I swear, and particularly describing the place to be searched and the person or things to be seized. So arbitrary searches and seizures have no place in a democratic society, and colonial grievances against unreasonable searches and seizure partly led to the revolt against the English authority. Now, the Fourth Amendment to the U.S. Constitution, the one we just read, guarantees the right of citizens to be secure from such arbitrary searches and seizures. So hopefully that makes sense. And now we're going to talk a little bit about some of the wording that was in that Fourth Amendment. So the constitutional standards for searches and seizures are contained within that Fourth Amendment. And the terms reasonable and probable cause provide us with a very fine but significant weight to balance those scales of justice which measure the conduct of all people. And without what is referred to as probable cause in the first part of the Fourth Amendment, called that the reasonableness clause, the laws that govern us might easily be, they might come unbalanced. And that is too permissive or maybe even too restrictive. And the second part of the Fourth Amendment, called the warrant clause, states that all warrants, search or arrest warrants, have to be based on this thing called probable cause. Well, so let's start off with reasonable, and this term that they call reasonable suspicion, and then we'll kind of work our way up this continuum, if you will. So the rules for determining what constitutes a reasonable search or reasonable seizure result again from the interpretation of the first part of the Fourth Amendment, which states the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizure shall not be violated. So reasonable means sensible, justifiable, how about logical? And a key determinant in whether an officer's actions are lawful is whether the officer has reasonable suspicion that criminal activity is in fact occurring. So the constitutional standards, again, are contained within the Fourth Amendment, and they talk about reasonableness. And this is a legal standard. Reasonable suspicion is a legal standard defined as a particularized and objective basis for suspecting the particular person stopped of some type of criminal activity. And the basis for this, or the basis for this, the Terry stop or stop and frisk, as you've probably heard, this Terry versus Ohio case, is based on reasonable suspicion. So let me give you the book definition. Reasonable suspicion, also referred to as arguable suspicion, is a legal standard that was defined in United States versus Cortez in 1981, again, as a particularized and objective basis for suspecting the particular person stopped of criminal activity. So hopefully that kind of clears that up. And it's this reasonableness that is the basis for this Terry stop and frisk, or the Terry versus Ohio case. And reasonable suspicion requires less justification than probable cause. And it's based on this case law that I'm going to talk about in a second, which is United States versus Arvizu, and that's a 2002 case. It's based on what we call the totality of circumstances. So in United States versus Arvizu, the Supreme Court reversed this decision, relying on past court decisions that reasonable suspicion is based on the totality of circumstances. The facts on which suspicion is based must be viewed as a whole, and they are not to be examined individually. Likewise, stated that the test for probable cause should be a totality of the circumstances. So just to kind of clear it up, the definition for totality of circumstances means considering all the factors involved. So the lowest level of a detention, if you will, is going to be this reasonable, reasonable suspicion. And then we kind of move up a little bit into this thing called probable cause. And the concept of probable cause is one of the oldest and most important in criminal law, having existed for more than 2,000 years, and occurring in both Roman law and in common law of England. And one of the big cases that outlines this is Draper versus United States, and I'm not going to go into it, but it is a Supreme Court case, Draper versus United States, and in that case it was said that probable cause exists where the facts and circumstances within their, being the arresting officer's, knowledge, and of which they had reasonable, trustworthy information, are sufficient in themselves to warrant a man of reasonable caution in the belief that an offense has been or is being committed. Now, another case, and you don't have to know all the cases, just kind of the words. In Smith versus United States, they define probable cause as the sum of the total layers of information and the synthesis of what the police have heard, what they know, and what they observed as trained officers. And they say, we, the courts, weigh not individual layers, but the laminated total. So basically, probable cause is reasonable grounds for presuming guilt. Facts that lead a person of ordinary care and prudence to believe and consciously entertain an honest and strong suspicion that a person is guilty of a crime. So we have the probable cause concept. So again, reasonable grounds for presuming guilt, facts that lead a person of ordinary care and prudence to believe and conscientiously entertain an honest and strong suspicion that a person is guilty of a crime. So you can see reasonable suspicion on this side is needed to stop somebody and detain them, and probable cause is needed to search or arrest them. And we're not going to go into all criminal law, but you start at the very beginning, and I don't want to confuse you, but you start with what they call a consensual encounter, where you need neither of these two. Then you can go up to reasonable suspicion is what you need to stop and detain someone, and then you need probable cause to arrest and search, or search and arrest. And hopefully that kind of makes sense. So as a review, probable cause, Smith versus United States, talks about the sum of the layers of information. We kind of went through that. And the sum of these layers can be based on a couple of different factors, and we're going to have to go through these because, again, I want to make sure I get done in 60 minutes. By observations by officers. So observational probable cause is what officers see, what they hear, smell. That is evidence presented directly to the senses. This is similar to eyewitness testimony and is the strongest form of probable cause. The courts have generally recognized certain types of events as being significant in determining probable cause, like suspicious activities, and that can actually contribute to probable cause. So the next one, expertise of officers. Expertise and circumstantial probable cause are often tied to observational probable cause. Police officers' experience and knowledge of criminal traits and their ability to put the pieces together, if you will, may also contribute. So an example they give is 2 police officers questioned 2 men seen driving from an alley at 2 a.m. The officers noted the license number and the occupants' names and questioned the driver and passenger. The 2 men were allowed to continue, but a short time later, when the officers learned there was a burglary nearby, they forwarded the description of the car and its occupants to the local police, who later apprehended the suspects. Now, a search of the vehicle revealed burglary tools as well as the property taken in 2 burglaries, which led to the arrest and conviction of the 2. So expertise and circumstances or circumstantial probable cause. And that also kind of goes into play for the next one. I kind of did 2 at the same time, these circumstantial factors that go into that. And then finally, information communicated to officers, or informational probable cause. So informational probable cause covers a wide range of sources, and in the case previously described, the information about the 2 suspects forwarded by the police to the nearby town constituted informational probable cause because the officers were the ones that provided the information. The major categories of informational probable cause are official sources and victims of crimes and informants and witnesses. And then the official sources include like police bulletins and broadcasts and even roll call information. So this probable cause can be based on observations by officers, expertise by officers, circumstantial factors that are built in there, and then also information that's communicated by officers as well. And if you look at this diagram, you can also find it on page 304 in your textbook. You can see the police citizen contact. This is progression from what we call reasonable suspicion to probable cause. So if you look up here, okay, so it's like no contact, and here, voluntary citizen contact, information gathering, no suspects. You don't need any suspicion. So for what they call a consensual encounter or a consensual contact right here, you can walk up to anybody and talk to them about stuff as long as you're not detaining them. They are free to leave at any time. You can ask them, hey, how's it going? What are you doing? It's non-custodial. Okay, it's more info and conversation. That needs no type of legal backing whatsoever. Now, if you go down below, reasonable suspicion. This is for if you're going to investigate a crime or stop someone or detain them. And that would include even in a traffic stop. They made a violation of law in front of you. So now you have reasonable suspicion that they did this violation. So it's kind of considered for an investigatory stop. Okay? And you don't need any other suspicion. Okay? You just reasonable suspicion. And then finally at the bottom, probable cause. And when you have probable cause, this is enough for you to search and arrest. So you can see the progression from basically the consensual contact to reasonable suspicion to probable cause. And that's kind of how it works. Now the voluntary contact, very, very quickly, well, let me go back to that continuum here and talk for a second. So police officers interact with citizens on several levels. And on the first level, which we just discussed, was the voluntary contact. Officers asked to talk with a person to get information, etc. Like they might canvass the neighborhood door to door for information, or they're walking a footbeat and they just come up and say, hey, how's it going? What's going on, etc. And the officers do not suspect the person of any involvement in a crime. And they can do that. And at the next level is a situation when the officer might suspect a person may be involved in crime or about to be involved in some type of, or they're involved in some type of behavior that leads them to believe they might be involved in a crime, and that's where they're going to stop them. So if it can start off as a consensual encounter, and if you start to get some different facts, in order to detain a person, you're going to need what's called reasonable suspicion. And then finally, at the end, if you're going to search or arrest, you're going to need that probable cause. Now, the voluntary contact is a very worthy objective when interacting with citizens, and the key to that, creating that voluntary contact, is to request cooperation in a manner that suggests an option, or simply to strike up a normal, non-coercive type conversation. And the officer's exact words are going to be very critical. The officer must request or invite somebody's participation, not order or demand or require, because then it becomes coercive and it changes from your voluntary contact. And advantages of voluntary contacts include a lower probability of causing people to be defensive, and a freer flow of information, and also a increased likelihood that somebody will consent to you doing it. So that's the voluntary contact. It's request, not demand, and you don't need any suspicion. Now, the Terry stop, again, and we'll talk about the detention. One of the basic responsibilities of police officers, and one heavily reliant on reasonableness, is investigating suspicious behavior. And officers may simply talk to someone acting suspicious and decide no crime seems to be in progress or about to be committed, or they may confirm their suspicions and investigate further. And the simple act of wanting to make contact with someone based on reasonable suspicion may lead to a stop, also called an investigatory stop, or a field inquiry, a threshold inquiry, or kind of what we refer to as a Terry stop. Now, an investigative detention occurs when an officer who has stopped a person based on reasonable suspicion needs a little time to investigate the relevant suspicious circumstances that led to the stop in the first place. And because the standard for detention is reasonable suspicion, an officer who refers to having or not having probable cause is misinformed. Probable cause has never been a requirement for detaining someone. It's been a requirement for searching and arrest. So the Terry stop, a simple act of stopping someone based on reasonable suspicion. And the detention occurs when a stop is based on reasonable suspicion and requires a little more time to investigate, again, those basic or relevant suspicious circumstances. Now, the basic legal consideration in a stop situation were set forth in that landmark case that I keep talking about, Terry versus Ohio. And this case also set forth a stop that involves what we call a frisk or a pat down. And just very quickly, it was a detective by the name of McFadden, a veteran police officer with over 30 years of experience, saw two men standing near a jewelry store. And they seemed to be talking, but to McFadden, they didn't look right. And he suspected, based on their actions, they were casing the store and possibly armed, like they were going to do a robbery. So he watched for a little while, and he saw the men looking into the jewelry store window, and they walked around the corner and then came back to the original spot, and then a third person joined in. So deciding to act, McFadden approached the three individuals, identified himself as an officer, asked for their names, and then ended up grabbing one of the individuals, John Terry. And McFadden made a quick pat down of the person's outer clothing. He didn't stick his hand under their jacket or in, just on the outside, and felt what to McFadden was a gun in Terry's coat pocket. and he detained them, and it turned out it was a .38 caliber revolver. Now, there's a lot more to it. Another individual was found to be in possession of a firearm as well. But that's the Terry stop. And anytime you believe, an officer believes, if you have reasonable suspicion to stop someone and you believe that person is armed, based on this court case, you are allowed to pat someone down. And that is, again, an exploratory search of an individual's clothing. And that search is the stop and frisk. So the stop is the reasonable suspicion for your investigation, and the frisk is the patting down or minimal search of a person's outer clothing to determine the presence of a dangerous weapon. So hopefully I've got that through. And a seizure would then be a forcible detention or taking of a person or property during an arrest. So here's a link to a video that you can look at that talks about stop and frisk, the good, the bad, and the ugly as it relates to New York City PD. And you can watch it and you can kind of make your own determination on what you think about it. So we talked about a seizure just a minute ago. Whenever a police officer uses physical force or a show of authority to restrain an individual's freedom to walk away. And a search is when an officer explores an individual's clothing. Now remember, a stop and frisk is not an arrest, but it is a search and seizure, but it's limited. And when you talk about searches and seizures and things like that, we have to understand there's a length of time for the detention of individuals, and it needs to be what we call reasonable. Okay, so we can't detain someone for 2 hours trying to figure something out or a way to arrest them. So that length of detention, again, has to be reasonable. And they don't really define a time frame, but usually it's long enough to complete whatever investigative task that you need to do. And if you can't find anything else to raise the level enough to arrest somebody, you may have to actually let the person go. And then finally, use of force during a detention should be minimal. So, but it can be more for safety. So what about, so we've talked a lot about detentions and use of force and different things like that. So length of detention, we talked about where a Terry stop kind of takes one of two paths. It either progresses to probable cause to arrest, or it fails to develop that probable cause, and you're going to have to let them go. And because this stop is a seizure and is governed by the Fourth Amendment, again, the cornerstone is reasonableness. So we have to kind of think about that. And the length of the detention, again, is very, very important. And as such, courts have generally held that investigative detentions are to be resolved within a time frame measured more in minutes than hours. And we talked about use of force during a detentions, and courts have generally held that officers may use reasonable minimal force to safely conduct an investigative detention. So from a practical standpoint, if an officer finds the need to use more than a minimal amount of force during a Terry stop, there's a good chance that the detainee is doing something at that point for which the officer would have probable cause to make an arrest. And then we move down to like this thing called plain view and feel and touch. And plain view refers to evidence that's not concealed and is seen by an officer engaged in the lawful activity. And in discussions of plain view evidence, an officer's vision can be augmented with binoculars and flashlights, but it's not proper to move or pick up items without probable cause, and I'll get a little bit more into that. So let's look at plain view, plain feel, plain touch, and talk about the plain view doctrine. This allows the warrantless seizure and use of evidence of an object that is seen in plain view by an officer who is engaged in lawful activity. And that's the essence of the plain view doctrine. Now, there is a little bit more to it, but we're not going to have time to go over all of the information there, so I'm just going to kind of give you the bigger pieces of it. So the warrantless seizure and use as evidence of an object that is seen in plain view by an officer who is engaged in lawful activity. Now, plain feel and plain touch refers to an officer who feels or touches something suspicious during the course of lawful activity and can investigate further. So closely related to the plain view doctrine, this plain feel or plain touch is used in several states. So there's a pivotal case in the plain feel or touch doctrine, Minnesota versus Dickerson, where two officers saw Dickerson leave a crack house, and upon seeing their marked squad car, they abruptly turned and walked in the other direction. This aroused the officer's suspicion, so they followed Dickerson into the alley, ordered him to stop, and patted him down, and they found a suspicious small lump in his jacket. Now, Dickerson was arrested and charged with drug possession, and the officer testified in court that during the pat-down, he felt a small lump in Dickerson's front pocket, and after manipulating that lump from the outside with his fingers, determined it felt like a lump of cocaine, but never thought it to be a weapon. Now, the trial court found the search to be legal under the Fourth Amendment, stating basically there's no distinction as to which sensory perception of the officers uses to conclude the materials as contraband. An experienced officer may rely upon his sense of smell in a DUI case, etc. So sense of touch, grounded in experience and training, is a reliable perception. Now, the Minnesota Supreme Court, the higher court, they overturned the conviction, stating that the sense of touch is less immediate and less reliable than that of sight, and is far more intrusive to the personal privacy that is at the core of the Fourth Amendment. And the U.S. Supreme Court upheld the ruling of the Minnesota Supreme Court that the seizure was invalid. But you can see, so plain feel, it does play a role in there. So you have these two doctrines, and here's kind of a chart that shows you some others. So you have plain view, which is allowing the seizure of apparent criminal items. You have plain feel, where an item is felt during a lawful touching and is immediately apparent as contraband, like a weapon. Plain smell, officers and dogs can use the senses, the smell senses, to detect the presence of seizable objects, alcohol, marijuana, different things. Plain hearing, conversation carried on in the presence of an officer or informant can be lawfully overheard. And then plain shape, like containers, can be opened where their outward appearance reveals criminal content. So this chart is very, very helpful when it comes to this plain view and plain feel and plain touch doctrine. So what about some other different things? Well, thermal imaging, this is kind of interesting. This subject of searches has received close scrutiny by the courts and remains in the public eye, an avenue vulnerable to invasion of privacy by the government. And there's a case in the United States, Kylo versus United States, where the use of a thermal imaging device to detect activity inside of a house was deemed a violation of the Fourth Amendment. Now, you can use a thermal imaging device outside in the middle of the night and shining it on the ground to track, let's say, footprints that are warm in grass or on the ground or things like that. But shining it directly at somebody's house is kind of a different story. But again, take a look at the case if you have time. It's a very interesting case talking about thermal imaging devices. And then what about something new? Because we're going to start to see this. Drones, these unmanned aerial vehicles, aerial vehicles referred to as drones. And there's a case already, State versus Brossart, and I'll let you kind of take a peek at that one. But that's going to be another interesting case that's going to come up, what is going to be the use of drones when it comes to searching and seizing. And are border checkpoints kind of a good thing? And why or why not? And speaking of checkpoints, we're going to kind of go over those right now. So border checkpoints, because they serve a broad social purpose, have been declared constitutional. Sobriety checkpoints, serving the broad social benefit of protecting motorists from drunk drivers, are another form of stop that have been declared constitutional. Now, sobriety checkpoints used to be, we called them driver's license checkpoints. Well, you can't just stop and do those driver's license checkpoints anymore, but the courts have actually held that sobriety checkpoints, because they serve that broad social benefit, are okay, and you can use those type of checkpoints. Well, what about informational roadblocks? Not maybe a checkpoint, but even a roadblock, but it could be a checkpoint. And informational roadblocks have also been declared constitutional, where they've allowed roadblocks to be used where police are merely seeking witnesses, or they're trying to get information about a major crime, or things like that, or passing out flyers. Now, drug checkpoints, that's kind of a different story. So these have been deemed and declared unconstitutional and a violation of the Fourth Amendment to the U.S. Constitution. So we can't do drug checkpoints. So how about searches with a warrant? So we've talked about, voluntary contacts, those consensual encounters, and we've talked about reasonable suspicion to detain, and we've talked about probable cause to search and arrest, and we talked about the Terry stop, which is a detention, and it's based on that Terry versus Ohio case, and it gives you the right as a law enforcement officer to pat down the outer clothing of someone if you believe they are armed. That's where the Terry case comes in. And all of that is without a search warrant. Well, what about with a search warrant? So lawful searches, because remember the Fourth Amendment talks about even probable cause. No warrant shall be issued but upon probable cause. So remember the warrant clause that's built into the Fourth Amendment. So a search warrant is an order based on probable cause, and it's issued by a judge. And officers basically prepare what we call an affidavit, and it's a written statement about a set of facts that establish probable cause. So when the judge reads the warrant, they will read the statement of probable cause. So a search in the context of the Fourth Amendment involves governmental invasion of privacy. And remember, searches are intended to obtain incriminating evidence, but must be justifiable. So again, the principal justifications established by the courts for conducting legal searches are a search warrant's been issued, and no warrant's been issued, but someone gives you consent, or you have some type of emergency situation, or perhaps maybe where there's no expectation of privacy. And I don't want to get too far ahead, but we're talking more on this time now about search warrants. So kind of back to it. So officers prepare this affidavit. It's the written statement of facts that are to show probable cause. And it also shows what may be seized. So it has to be specified in the search warrant what you're looking for, the contraband, anything illegal, or things like that. So what may be seized has to be in there. Must be specified in the search warrant. The contraband, anything illegal to import, export, produce, or possess. And then, of course, the exclusionary rule comes into play, and I would highly suggest you look at Weeks versus United States, or even Mapp versus Ohio. Those are two big cases that are relating to search warrants. And there you go. Here's a link to a video for Mapp versus Ohio, so you can kind of understand a little bit more about that particular case. So again, searches conducted without a warrant. So here's the one with the warrant back here, and this is kind of what you need. You need the level of probable cause, and then searches without a warrant, lawful searches. And I think I kind of mentioned that quickly a second ago. You can conduct searches without a warrant under a couple different realms. Consent would be one, meaning somebody says, yeah, go ahead. An emergency being two, what we call exigent circumstances. Searches incidental to a lawful arrest, meaning that if you're arrested, we can search you. There's an exception called the automobile exception, and I'm not going to go into that in great detail because I probably won't have time. And then where the person has no reasonable expectation of privacy. So let's kind of move on because we're starting to run out of time a little bit. And let me go over real quick just again the exclusionary rule before we kind of get into arrests. The exclusionary rule is a U.S. Supreme Court ruling that basically said any evidence seized in violation of the Fourth Amendment will not be admissible in a federal or state trial. So just kind of keep that under your in your mind as we start to look at different levels of searches and things like that. So an arrest, the lawful taking of a person into custody by the actual restraint of a person or by his or her submission to the custody of the officer so that he or she may be held to answer for a public offense before a judge. And there are four elements to an arrest. The intent by an officer to make an arrest, the authority to arrest, a seizure or restraint, and an understanding by the person that he or she is in fact being arrested. And then when you do make the lawful arrest, warnings must be given to a suspect who is going to be interrogated by police while in custody. And this is based on the Miranda decision, and it basically has four specific rights. Now, in order for Miranda to actually apply, and I think I have a link to the video in here from Miranda as well, there has to be two pieces that are present. It's custody and interrogation. Without both of those pieces, you don't have to advise someone of their Miranda rights. So custody and interrogation. Now the rights there's four of them here that you have to read. Typically they might even be on a Miranda card that is issued to the officer, so that way the officer can be consistent in reading the person their rights. So you have the right to remain silent. If you give up the right to remain silent, anything you say can and will be used against you in a court of law. You have the right to speak with an attorney and to have that attorney present during questioning. And if you so desire and cannot afford one, an attorney will be appointed free of charge. And then typically some Miranda cards will ask questions like, do you understand the rights I've explained to you? And someone will say yes or no. And it doesn't have to be exact, but in its best form, it needs to have these four specific rights there. And again, it has only custodial interrogation. That's when Miranda applies. So when a suspect is under arrest and you're going to interrogate them, that's when it applies. Now, when a suspect is not under arrest but is deprived of freedom in a significant way, so these are the times when it would definitely apply. So hopefully it kind of makes sense there. They also have what they call the inevitable discovery doctrine that holds that illegally obtained evidence may be admitted at trial if the prosecution can show that evidence would have been discovered inevitably. And then waiving of the Miranda rights, it has to be voluntary and preceded by Miranda. And here's the case that I put in here for you where you can look at it and kind of get a better understanding of the entire Miranda case as well. Okay, so I know I covered a lot of things very, very quick. And so I would suggest that, again, because I wanted to keep the lecture to about an hour and we're just coming up on that, that you go back through your textbook, especially in this particular lecture, and look at a lot of the terms that you'll see that are within the outer columns, if you will, of the textbook. And those will really help you add some context to some of the things that I've been talking about this evening. So with that, again, the key terms at the front of the textbook, the discussion questions at the end of the textbook. If you have any questions, feel free to put them on the general discussion board, or if you don't want to put them there, you can send me an email. And again, reminder about the student resources. So with that being said, until next time.